to. As an amicus to the other injunction I recognize courts are looking at, I think bucket 3 could be available. We aren't seeking relief when it falls into bucket 3 because, as I was saying earlier, we're not going to be seeking relief for other parties. This court's cases, like Brackeen, make very clear we aren't suing to vindicate the injuries that third parties and our residents are suffering. So when states come before you, the questions that you would ask are the alternative ways of remedying our injury going to be practically or legally workable? And you're going to ask, did Congress authorize it, which gets to the vacator question, which gets to the Hobbs Act question, and so on. And on that first bucket, which I think describes this case well, I had a hard time with some of the colloquies earlier today because I think they were missing some really serious burdens that the states are still going to have to bear in this case if we get something less than a nationwide injunction. I think it's going to hinder the administration of our benefits programs. I think it's going to hinder the participation in our benefits programs. And I think it's going to produce unprecedented chaos on the ground. And I might offer examples of each.
Before you do, I'm sorry, I got one more.
Not at all.
How would you get the merits of this case to us promptly?
So there's two different ways that this court could think about doing it. So the first is, I heard a couple colloquies earlier today to suggest that maybe the states should sort of have to take some of the burdens on ourselves because, okay, some people move in, maybe that's just something that equity shouldn't care about. And it may be true, this is Hornbook equity, that in some cases states don't get complete relief for the harms that they suffered. We just have to eat some of the administrability burdens. But the merits have always come into that, because that is just about remedying a party's own injuries. And the strength of the ability to remedy our injuries is going to turn on a peak on the merits. This is partially Ohio versus EPA and building on Justice Kavanaugh's Labrador concurrence, where this court said you might have some states who really like a policy and some states who want to get relief from the policy, and how you reconcile those two things, who should get relief, who should benefit from the policy, will turn in part on a peak at the merits because we have a greater right to relief from it.
I appreciate that. How do we get to the merits fast?
This court could set supplemental briefing on the merits by an order tomorrow if it wished, specifically to say the federal government has proposed that states get less than complete relief in this case. We could not possibly think about giving the states less than complete relief without looking at the merits.
Okay.
We want briefing.
Put that aside. Assume we've just got the remedial question before us, and we're going to decide the remedial question one way or the other. Then what?
Oh, then I share some of Justice Kagan's concerns from earlier that it would rely on the
I appreciate you share those concerns. How would you address them? How would the states plan to get this case to the court promptly?
I think it's very hard to think about how the states would lose this case given the state of Supreme Court precedent. It creates very weird incentives on the certiorari docket when there's already binding precedent from this court. We do suffer harms from the application of this executive order beyond our borders that we need relief from. If we don't get a full remedy from that, I suppose we could ultimately seek cert before judgment on the basis that we still have Article 3 injuries that we're suffering, but we'd be asking this court to grant review from a circuit precedent we won on the basis that we have continued injuries. It's not impossible. This court knows best when it grants cert and when it doesn't. I would think it's not the cleanest way to tee up a case historically, and so it would raise some real concerns to the colloquies earlier today about how this case would ultimately come before this court.
Are you telling us that we really can't decide the question that we asked to have briefing and argument on without taking a peek at the merits?
So I'm not saying that at all. So there's two different ways to think about this case, Your Honor. One is to say, absolutely, the states need to get complete relief for their injuries, and then let's figure out the best way to do it, and we think the alternatives are not workable and not legal. If this court is going to entertain giving us anything less than full redress for all of the Article 3 injuries we bring before you, I don't see how that can be entertained without a peek at the merits, because you always look at the merits to decide should we get 100% or 90% of our own injuries redressed.
Well, would a decision on the matter that is, I understood to be before us, the narrow question that I understood to be before us, be helpful in any way if we do not peek at the merits and we also do not decide whether you have standing?
So I'm not sure how you could decide whether or not we got an appropriate scope of relief without figuring out what our own injuries are. Because how you decide, this is the United States' own argument, how you decide whether or not we should get relief for our own injuries turns on what our injuries are that require relief. And so I do think we have pretty significant pocketbook injuries, like in Nebraska, to the tunes of millions of dollars. And whether we get those remedies or don't get those remedied is going to turn on the merits, is going to turn on the nature of the harms, and then ultimately the workability of the alternatives.
Thank you, counsel. Justice Thomas, Justice Alito.
Well, General Sauer began by outlining problems that he sees being created by universal injunctions. And he said that the issue was a non-ideological issue and a nonpartisan issue. Do you agree with that?
I do think presidents of both parties have objected to nationwide injunctions. I agree.
So what do you say about the practical problem? So let's put out of our minds the merits of this and just look at the abstract question of universal injunctions. What is your response to what some people think is the practical problem? And the practical problem is that there are 680 district court judges, and they are dedicated and they are scholarly, and I'm not impugning their motives in any way, but sometimes they're wrong. And all Article III judges are vulnerable to an occupational disease, which is the disease of thinking that I am right and I can do whatever I want. Now, on a multi-member appellate court, that is restrained by one's colleagues, but the trial judge sitting in the trial judge's courtroom is the monarch of that realm, and there are situations in which trial judges, the president does something. It could be President Trump, it could be President Biden, it could be President Obama. The trial judge says this is unlawful, and I'm going to enjoin it. And I'm convinced I'm right, so I'm not going to stay the injunction. And then an application is made to the Court of Appeals to stay the injunction. The Court of Appeals gives it the back of the hand, and then the case comes immediately to us in the context of an emergency application. And some of us have said, well, we don't think we should do anything in those situations unless it is indisputably clear that the court below was wrong. So what do you say to that practical problem?
So we're mindful of the practical problems. I will say the states have had a through line as well across administrations. We have never believed, even as nationwide injunctions restrained policies that we favored, that they were categorically off the table. We've always taken the position that they are sometimes available in narrow circumstances, whether we like the policy or don't like the policy. And so you might have some cases where the nature of the harm, this is the DACA example from my friend on the other side, where the nature of the harm which was Texas saying it had to give benefits to residents in the state, is actually entirely remedied by a nationwide, state-only injunction that applies just to Texas, because that might incentivize individuals to leave Texas, and then Texas doesn't have to give them benefits anymore. So you might have a case like that. But sometimes you are going to have cases where it is impossible to remedy the state's own injuries, and the alternatives are not practically or legally workable, and that describes this case perfectly. And so I don't think the answer is a bright line that means even in those situations, it's not possible for the states to get relief.
In deciding the question that is before us here, do you think we should, never mind, I withdraw that. I have no further questions.
Justice Sotomayor?
Let's start with an answer you've been trying to give and haven't completed, which are the general suggested there were two ways that your injuries could be remedied. He claimed they were both presented to the court below. I didn't see that, but that's a matter that we could check on. Do you agree with me that they were not presented to the courts below?
I do agree with you. So I want to be very clear, because I think there's some confusion across the briefing here.
Right.
We agree, and I don't think the First Circuit disagreed. They objected to the nationwide injunction in the district court, and we attached the briefing and we attached the transcript. What they didn't do is provide some of the alternatives they've pressed in two sentences in their emergency application.
Okay.
Yes, they did not.
So now go through why you question whether there are two suggestions now that they've only raised before us are inadequate to remedy all of your harms.
Yeah,
because complete relief, he says that there is situations in which you grant relief that will benefit third parties. Why is your relief necessary to give you complete relief, even though it benefits these parents in other jurisdictions?
So I don't think there's any serious dispute that if you limit the relief to babies born in New Jersey, we won't get complete relief, because 42 U.S.C. 1396A, the Medicaid statute, requires us, the states, to do the citizenship verification. So it's not true that they can simply handle it all for themselves. Federal law requires us to undertake those responsibilities. And we have, in New Jersey, 6,000 babies born out of state every year. When they come into the state and they need benefits, the Boyle Declaration from Massachusetts suggests that's going to cover 40% of kids. They come into our state, they need benefits. We have to do citizenship verifications, which is a burden for us.
That's for you in New Jersey, but there's, I think, how many states?
That's just an example. We have 23 attorneys general in this.
23
exactly right.
attorney generals. So 23 states are going to have babies who were born somewhere else without a birth certificate that you're now, if they move into your state, going to have to do checking on.
And that comes to the United States' alternative, Justice Sotomayor, which is they say, okay, maybe their citizenship turns on when they enter New Jersey, maybe for some purposes, maybe for all purposes, depending on which sentence you're looking at in the emergency application. And there are three problems either way. The first is it will undermine the administration of our benefits program. So individuals will move in. When they were born, they were treated as non-citizens. They didn't get Social Security numbers because they wouldn't have been eligible for the enumeration at birth program in their states. And they're going to arrive and they're going to seek benefits that we administer. But federal law requires that they have Social Security numbers for the administration of those benefits. This is 7 U.S.C. 2025 for SNAP. This is 42 U.S.C. 1320b7 for TANF, for Medicaid, and so on. So they're going to need to have Social Security numbers. They're going to arrive without them, even though they were, under this court's precedents, citizens who should have been in the enumeration at birth program, who should have had Social Security numbers. And it's going to be a burden on us, either in delaying the benefits, training county social service workers, in having to administer benefits without the SSNs on a provisional basis. So that's the administration of the benefits. Let me give an example on participation, which we have responsibility for as well. These are babies who were told that their families were told that the babies are undocumented, they aren't citizens, they're not eligible for these federal programs when they were born. They come into our states, they think they're now ineligible. They don't realize their child is a citizen entitled to these federal benefits. And so what will happen is we bear the responsibility, putting in our own state Medicaid plans, of getting them enrolled. And that's 42 U.S.C. 1367BB. So we're responsible for putting in our plan how we're going to enroll them. We have to incur substantially more costs to get them enrolled in our programs, because they think they're undocumented, they think they're ineligible because of where they were born, even though their citizenship has now turned on when they cross state lines. And then the last point is, we've never in this country's history since the Civil War had your citizenship turn on when you cross state lines, so we don't have answers to these workability questions, not just because it wasn't presented in the district court, not just because it's two sentences in an emergency application, but because for over a century, executive practice has been uniformly to the contrary, building on this court's decision in Wong Kim Ark. So we genuinely don't know how this could possibly work on the ground. And although my friend on the other side has complained that they weren't able to give guidance, the states didn't object to guidance. The states have no quarrel with internal steps. And if they want to put out guidance that says, if Wong Kim Ark gets overruled, this is what we would do, that's fine. What they can't do is require us to take any steps or issue guidance that requires everyone to start planning for something that is so patently against this court's own settled precedent.
Now, going back to the history question that Justice Thomas started with, you relied on the Bill of Peace, you relied on the tax injunction of the 19th century, and not so far in the 19th century, 1891, just about the time that the 14th Amendment was adopted, okay? At any rate, there are other cases, one of our amici points out to them, the Pierce versus Society of Sisters case, the West Virginia State Board of Education case, those were earlier than the 1960s. In the Pierce versus Society of Sisters, the court affirmed a universal injunction that wasn't even sought by the parents, correct?
That's right.
And there, what we said was their states were imposing criminal penalties on parents who sent their children to private school. And just two plaintiff schools sued against that penalty. They sought and won an injunction that categorically restrained the state from enforcing the law. That was 1925, correct?
That's right.
And similarly with West Virginia, saluting the flag by Jehovah's Witnesses. The injunction was universal. So in answer to Justice Gorsuch's point, we've had universal injunctions in some form, correct? Since the founding.
That's right. If I can make 2 points on that, Justice Sotomayor.
Correct?
Exactly. So I agree with your reading of the equitable history, that it goes back from the English Pill of Peace through Equity Rule 48, through the tax collection injunctions, through Equity Rule X, through the Ex parte Young period you're referring to, through AARP just a few weeks ago. So I agree with your read of the history. But I just want to make one quick point.
Well, let me, go ahead, make your point, but I want to finish this thought, which is, you started earlier by saying universal injunction should not be the preferred remedy, and it should be limited. You've suggested 3 ways to limit it. I agree with you, those 3, and yours clearly falls within one. That's your claim. But the point that I think my 2 other colleagues are raising is, how do we ensure district courts are following that?
So if I can make a point about the history and then make a point about the guidance. On the history, I understand that the United States at the podium today tries to make the history all about what it calls indivisibility cases where there's just a unitary on-off switch, as it were, and either something happened or it didn't happen, like a redistricting plan needs to be completely redone or a power plan is on or it's off. But if I could give an example that shows it's not quite so limited and it very much requires looking more broadly at what's practically or legally workable on the ground, I would point to apportionment as an example. So say that there's an executive order that says we're just not going to count minors, people under 18, in apportionment anymore. We're only going to count people who are voting age. And the state of New York files a lawsuit, and it wins its lawsuit, and all of its 17 and under-year-olds get counted for apportionment. That isn't indivisible in any way. It's not a redistricting plan, it's not a power plant, but it is going to skew apportionment in a way that is totally unfair, practically and legally, to third parties, because now 17-year-olds are being counted in New York, but they're not being counted in Oklahoma. And you would end up messing up apportionment between states for that very reason. And that shows, as just a broader insight, that we've always looked to the harms that third parties will suffer as negative externalities of court orders. And that's our submission here, that to accept what the United States wants as against our injunction and to say that it turns on or off when you cross state lines doesn't just harm the administration of our benefits, doesn't just even harm enrollment in our benefits, also puts chaos on the ground where people's citizenship turns on and off when you cross state lines. If ICE has initiated a removal proceeding when you live in Philly and you move to Camden, I suppose the ICE removal is supposed to turn off at that point, potentially, because your citizenship status has changed. I don't know if you lose it if you move back to Philly, whether you were born in New Jersey or born in Philly, move to Camden and move back. It's a very porous part of the country. I don't know if the ICE removal turns back on when you cross state lines again. And that sort of chaos on the ground, those implementation questions we don't know, are serious third-party harms we've always taken into account. This is North Carolina versus Covington, where courts ask what's workable as an injunction matter, and it's also the winter factors, where factor 3 looks at the balance of the equities between the parties and workability and harm to them, and winter factor 4 looks at public interest and the negative externalities and workability problems we're imposing on others.
Justice Kagan?
General, you've had a chance to talk about your administrative costs and the workability problems that New Jersey would confront. But how about this magnet problem? I mean, it strikes me as completely obvious that if you have 2 states and they have different rules for citizenship and one benefits babies and the other doesn't, that everybody moves to the state where the more favorable rule exists. But why is it that preventing that harm from happening should count as providing you with complete relief?
So I think actually my point is somewhat different. I agree with you that the incentives could potentially factor into the calculus because we're ultimately experiencing some harm we might not otherwise to our benefits programs. But my point is different. Even if you just take normal migration for New Jersey, 6,000 babies born out of state, 8% or 8 million every year traveling across state lines without worrying about the incentives, we're going to be looking at that problem for how we administer benefits programs.
I got that. Are you saying we shouldn't consider?
No, I think you can. I think you can, Your Honor, and it's because of the nature of 3 things together. One is, it's the movement, but it's not just the movement. Two is, it's the fact that citizenship historically was something you had at birth or didn't have at birth, and so you arrived to our state, in theory, without birthright citizenship, because you would have been told when you're born in the hospital what you have or don't. And then the third, and this is really important, is the way that citizenship permeates so much, not just for individuals, but for what states are obligated to do, whether it's citizenship verification eligibility, whether it's enrollment in our own programs. Over and over, you see citizenship in Congress's own laws as the on or off switch for our own administration of benefits, and that's actually sort of unique. So I don't think every time people move between states, you automatically need to have a nationwide injunction. What you need is a demonstration about how that's going to contribute to the state's harm, and then, I think this is really important to colloquies you were having with the United States earlier, a court could, in an appropriate case, say, well, sure, state, you might have to keep some of the harm. We're only going to remedy 90% of your harm because it's too disruptive to everyone else. But I don't think you can do that in a case without looking at the merits, because whether we should get to 100% of our injuries taken care of or 90% of our injuries taken care of will always involve the strength of our merit showing, and I don't see how you could have a stronger merit showing than we have here. 127 years of Supreme Court precedent, over a century of executive practice, and congressional statutes that codified both into law in 1940 and 1952. And given that strength of the merits and the settled precedent, combined with our nature of harm, I don't think this is a close case for why we need national relief to remedy our injuries.
Thank you.
Justice Gorsuch, Justice Kavanaugh, Justice Barrett.
I have a question about the history. So Grupo tells us that we have to look back to 1789 in the High Court of Chancery. So I appreciate that there have been some cases from later, and you were talking about some of those with Justice Sotomayor from the early 20th century, maybe the late 19th century. Can you say, and let's say that I think the Bill of Peace is more like a representational suit that is the forerunner to the class action. What do you think is your very best example of something that would look at the period that Grupo tells us is relevant, that would support something that looks like universal relief?
So I do think from 1789, from English equity, I do think the best example is the Bill of Peace, and so I understand if we see it differently, it's a fair point. I will just say quickly on Grupo Mexicano, its own tradition, and this is sort of the analogical reasoning you talked about in Rahimi, it looks at that period, but in other times we've also looked at American tradition to see analogically how we've liquidated that tradition or not. And in American equitable tradition, this is Equity Rule 48, which specifically said non-parties are not bound by certain relief, and even as they may benefit from it. And I take that to be the principal reason my friend on the other side thinks that bills of peace look much more like class actions than they ultimately look like universal injunctions. And Equity Rule 48 was to the contrary. Tax collection injunctions in American history were to the contrary. So I just have a hard time with that reading, even though I agree with you that you would be starting in the founding trying to do analogical reasoning based on what Grupo Mexicano says, but using American equity to answer some of the unresolved ambiguities.
I completely agree with you. Need some analogical reasoning, and I don't think that Grupo completely rules that out. And I think even if you talked about the distinction between a Bill of Peace and a class action, you would be looking at some of that doesn't have to be called the same thing. I think the problem is when we have such a party-centric history, if it has to be reasoning that fits within the confines, then I think we have a little bit of trouble. Let me just ask you one question about relief. So let's say that I think that the states do need something broader in order to have complete relief, even if the universal injunction is too broad and inconsistent with Grupo. That isn't how the court below approached the question, because that isn't what the court below thought it had to do, because the court below thought it could just enter a universal injunction. So how would I go about crafting some sort of holding or decretal language that would take care of you and the fact that you need maybe broader complete relief than maybe an individual plaintiff would, right? Because the district court didn't go through that analysis, the analysis that you're telling us today. So tell me practically what that would look like.
So I think the district court in the Massachusetts case did actually do a very good job of this. It specifically said, I'm saying New Jersey as a stand-in, 23 Attorney General. Yeah. The states need this relief. And he didn't grant universal relief to the individual plaintiffs in that case. So he did actually craft different relief for different parties, and he said this is necessary for us. Part of why we're talking about alternatives in a different way at the podium today is because these alternatives were not presented to the district court. So the district court just had before him the idea that maybe we have to eat some harms or maybe we get universal relief. And of course we need universal relief given the strength of the merit showing as between those choices. I think what you could say is here there were two sentences in an emergency application that raise new alternative ways to remedy the harms. Those sorts of things need to be raised to the district court, and when they are raised to district courts in appropriate cases, when states file suit, courts should ask first, are those alternatives going to be practically or legally workable for the plaintiffs and for third parties? I agree to Justice Gorsuch's point. If the federal government wants to take on its own burdens, it can do so, but it can't just say that for third parties.
But you're talking about what would happen in the future. I'm talking about what would happen to you now.
Oh, so I think if the United States seriously wanted to press these alternatives with facts about how they would work and put that before the district court, parties can always put new alternatives in a motion to dissolve an injunction before the district court. That's something that has happened regularly when there's changed circumstances or new alternatives. They're welcome to do that in this case or in any other, but then they're going to have to put forward actual facts about how it's practically or legally workable. I will say on its face, these two sentences don't look practically or legally workable for the reasons I raised, but they'd have to make that showing in the district court in the first instance.
Thank you.
Justice Jackson?
So I guess I'm kind of hung up on the posture in which we find ourselves looking at these issues. Justice Alito, I think, focused on this a little bit, when he says that the district court makes this initial determination. It turns out to be wrong. The remedy, I thought, was to appeal. And I guess, for me, the question is whether and under what circumstances the government keeps on doing the thing that the court has found unlawful while the litigation is proceeding to determine whether or not the government's activity violates the law. We're sort of in an interim posture. Many of your arguments, and I appreciate them, are kind of couched in, the state is going to need complete relief for their injury, and that's true definitely as a final matter. But here we are at the beginning of this litigation. No one has determined whether or not the government's conduct is actually unlawful. We have a district court, several district courts, and now courts of appeals that say it is, and so, as an interim matter, we are saying the government has to stop doing it while we litigate the issue of the unlawfulness. To me, that kind of puts the whole thing in a different frame. It's sort of like, why isn't the question in this posture, in this circumstance, can the government or has the government shown that it is going to suffer some sort of harm from being made to completely stop this activity while we're litigating the lawfulness of the conduct? I don't understand. And then you say, yes, we're going to suffer harm. This is the balance of the equities that, part of the PI and the stay showing. But I just don't understand why that's not the focus here. And I don't know what I apologize because I didn't get a chance to ask Mr. Sauer this, and maybe he can address this on his rebuttal. But, what problem is the government facing as a harm matter from being completely told it has to stop doing this while we, the court system, determine whether or not its conduct is lawful?
So we included this in our application. We do think this case is quite unique in that I do think it's hard for the government to show in this particular case that it needs to be able to act contrary to this court's settled precedent. That's obviously come up in a couple of questions today. It's something, if I realize the elephant in the room, I've often been asked to assume that the merits are put to the side, and I'm fine assuming that for those questions. But to your point, you're not wrong. It is quite striking, obviously, that it's not just that district courts are saying, this looks like it might be unlawful. They're saying Wong Kim Ark settled this exact issue 127 years ago. This court has reaffirmed it since. Over a century of executive practices built on that, and Congress has codified that directly into law. So I do think it's a particularly unusual case for the government to be saying that it has been quite so harmed and needs this kind of relief. But at the end of the day, I'm happy to join issue on when relief may or may not be appropriate, and I just think we're clearly on the positive side.
But you're saying that at least in some circumstances, from your perspective, in order to even decide whether or not you are entitled to an interim complete injunction, the court's now going to have to peek at the merits while the merits are being litigated?
I think the court always has to peek at the merits in deciding whether the party itself should be getting relief from its harms, including complete relief, as even the United States accepts. So those are all four of the winter factors. You have to figure out what the irreparable harm is that you're trying to deal with. You have to figure out if we have a sufficient merits showing in order to eliminate that irreparable harm. And depending on the strength of the merits showing, you're also looking at winter's factors 3 and 4. So this court has given 4 winter factors that I think are quite useful in most cases. I took my friends on the other side to be be saying, well, beyond the winter factors, there's this bright line rule from Article 3 or the history of equity that just says it can never get to this point. I obviously disagree a bit with them on the reading of that history, but I just think it has no bearing on the case that the states bring to this court here.
Thank you.
Thank you, counsel.
Real trap shit, nigga.
Ms. Corcoran?
Mr. Chief Justice, and may it please the court, the executive order's stripping of citizenship from U.S.-born children is contrary not only to the 14th Amendment's plain text, but also our common law history, this court's precedent, a federal statute, and over a century of executive branch practice. Every court to have considered the issue agrees that the order is blatantly unlawful, a determination the stay application does not challenge. The government instead argues that Article 3 and equitable tradition categorically prohibit providing non-party relief from the order's enforcement regardless of the order's illegality or the irreparable harm it inflicts. The government is wrong. It is well settled that preliminary injunctions may benefit non-parties when necessary to provide complete relief to the plaintiffs or when warranted by extraordinary circumstances, both of which are true here. The court should reject the government's efforts to stay a preliminary injunction that maintains a status quo all three branches of government have ratified and operated under for over a century, and that prevent the catastrophic consequences that will result for the plaintiffs and our country if the government is allowed to execute an unconstitutional citizenship stripping scheme simply because legal challenges take time. I welcome the court's questions.
You say the government is wrong about the availability of preliminary injunctions. On what do you base that?
So I think that the two reasons I identified, one, it is well settled, and I understood General Sauer to agree today that universal injunctive relief is appropriate when necessary to provide complete relief to the plaintiffs. That is the case here, and I'm happy to talk about that. But I also, this court has long recognized the availability of universal injunctive relief in extraordinary circumstances where it's justified. I think I would focus particularly on the public interest and equities prongs of the winter test, and I'm happy to talk about that as well. But I think those are the two reasons the government.
Do you think that if, even if one considers the history not to support you, that the pragmatic considerations and the policy considerations should override that?
So again, I would put us in the complete relief bucket. So Mr. Feigenbaum, I'll put on my amici hat in answering that question. I understand General Sauer's proposal to be that we channel all of this through Rule 23. I think that is a historical one. It's inconsistent with the Rules Committee's understanding of the rules. Both, if you look at Rule 23, Rule 65, and Rule 71 together, they establish that Rule 23 is not the channeling mechanism that the government's suggesting. I'll start with Rule 71 because it's responsive, Justice DeBarrett, to your question earlier about whether non-parties can enforce orders. Rule 71 explicitly contemplates that and says if a non-party receives relief, they are entitled to enforce it. I'd point also to Rule 65, the preliminary injunction rule. In 2017, the Rules Committee considered a proposal from Professor Bray to amend the rule to prohibit relief to non-parties. The committee rejected that proposal because it found that it ran afoul of the Rules Enabling Committee. And then I'd end by pointing to Rule 23 itself, which says nothing about it being a channeling mechanism. In Principe v. Scarborough, this court said, we don't treat the rules as excluding background equitable practices. And here, Rule 23 doesn't even contemplate preliminary relief. It's focused on permanent injunctive relief, and I think that's because, as we've been discussing, it's very difficult to get class certification in time to have preliminary relief, so you're doing putative class relief, which is the exact same thing as what's happening here.
Well, why can't you get putative class relief in a preliminary injunction or TRO posture?
You mean, in the
get relief for a putative class in a TRO?
I certainly think you can do that recently in AARP. My point is when the court does that, it's relying on the equitable authority it has to enter that sort of relief, not on the Rule 23 mechanism, because the class isn't binding until after certification, until after final judgment.
If that mechanism is available, whether one way or another, doesn't that solve a large part of the problem in a way that complies with the rules, the problems with universal injunctions that have been identified by administrations of both parties. Go through Rule 23 and do what's needed there, and people are bound then, so that's a wrinkle. But why doesn't that just solve the problem?
Right, so they're not going to be bound until after you get past class certification. So we're talking
I understand that.
And for that reason, I would go to Justice Alito's point earlier that all you're doing is taking the non-party injunctions that are happening now outside of Rule 23 and shoving them into Rule 23. It doesn't address the forum selection concerns. It doesn't address the concerns about the emergency docket.
It complies with the rules. I mean, the law, we care about technicalities, and this may all be a technicality, but it seems to me the technicality of Rule 23 and the history of that provides, 23B2 provides a mechanism to do what's needed here in terms of getting relief to people. And if you have PIs available for putative classes, that seems to solve the issue for preliminary relief and the timing issue as well.
So B2 provides for permanent injunctive relief. It does not provide for preliminary injunctive relief. Again, Rule 23 does not purport to be the exclusive channeling mechanism. And as I said, the Rules Committee doesn't think it did. So it would be this court kind of projecting its own policy decision to treat Rule 23 that way. And I would come back again to Justice Alito's concerns. That is not actually addressing the court's emergency docket. It's just now we're slapping a label of class certification on it. So I would, and I'll make a second point on that and then say what I think the better way of approaching the problem is, which is I think that General Sauer and I are in agreement that the Venn diagram of cases that are appropriate for class certification and where injunctive relief I think would be appropriate is not coterminous. I think we could pursue successfully class certification here. I heard General Sauer to disagree, and I think it's because they're just different circumstances. If you look at the class certification requirements, commonality, typicality, they were actually added to Rule 23 in 1966, mostly to address the expansion of class certification to include damages suits. That makes sense there, but those were never requirements prior to 1966.
Ms. Corcoran, on the class certification point you've been developing, one response might be, and I just want to get your reaction to it, that by proceeding through the class mechanism, even a putative class mechanism, a court is making a preliminary assessment about who are the parties going to be before it and issuing interim relief so that it preserves its jurisdiction to issue final relief with respect to those parties. And that's very different, the argument would go, than simply saying everybody everywhere, nationwide, universally, or perhaps cosmically, stands to benefit from this decision without ever having to suffer being bound by it. Thoughts?
So I would say, again, that's an ahistorical approach. You haven't had that sort of Rule 23.
Assume for the moment that we read bills of peace, which I understand to be your best set of cases, to be prototypical of what is now Rule 23.
Right, and so the bills of peace and kind of going through, as Mr. Feigenbaum was talking about, Equity Rule 48 and then 38, in none of those circumstances were we doing this ex ante class certification determination. So the modern class action device actually looks quite different than it was for representative suits historically. So it would be putting on an ahistorical constraint.
I appreciate that argument, okay, but then now we're haggling over the history, which we have to do, I accept. But if bills of peace are understood, again, accept the premise, to be predecessors of Rule 23, then respond to the point that there is something fundamentally different about a preliminary injunction to a putative class that you found is likely to be certified and likely to succeed on the merits in order to preserve that court's jurisdiction to award ultimate relief to those parties before it, and that's categorically different than a universal injunction.
So starting with the presumption that was different about the bills of peace is that they were binding, I think sometimes, it's not clear always, at the end when they were getting to final judgment. I would go back to Grupo Mexicano, to Justice Barrett's point, although that was the high watermark of this equitable originalism, the way the court articulated the test, it focused on 1789, but the actual analysis in Grupo Mexicano focused on 1890 through 1942. And what the court found there is that there were numerous cases expressly rejecting the Moreva injunction, and that was confirmed in the 1970s when England adopted it and said, no, we've never done this before. We are in an entirely different world here. One, the cases that Justice Sotomayor laid out earlier all come from between 1890 and 1942, and they suggest that non-party relief was provided for outside of the class action context. But the fact that we have, I think, these very studied scholars in this rigorous debate about what the bills of peace meant, what the railroad cases meant, I think shows that this is very different in Grupo Mexicano. And for the court to kind of delve into that and adopt the categorical rule that the government is suggesting, I think is certainly an overcorrection. It's a hornet's nest on Article 3, right? It calls into concern APA, class action, a whole sort of things. I would suggest that the court instead focus on providing limiting principles within the confines of the Niken factors of the winter.
Is there a practical problem? So I want to put aside the history, and I take your points on that, and why you don't think Rule 23 fits. I take your point on that. But if putative class actions and preliminary relief are an option, what then is the practical problem you see as distinct from the current regime?
Well, if General Sauer is right in that there are class certification problems here, then in this particular case, you're going to have thousands of
Okay, I think
suits.
you would be arguing that the class should be certified here.
Right, but I'm saying the government is
So
suggesting
more generally, taking it out of this case, if you could, do you see practical problems?
Yeah, it would eliminate the associational standing trade cases, the cases brought by the Chamber of Commerce, the NRA, other associations that aren't suitable for class certification. I think also the questions again.
What? Can you explain that?
Well, they wouldn't. So if we were to seek cert, it would be on behalf of our individual plaintiffs. For the same reason that the government would have difficulty seeking class certification. The state government, I think, associations are not necessarily a good fit for that framework. Again, that's also not solving the court's problem. It's just channeling the problems through a different mechanism.
I don't think that can be solved, just to be honest, but that's a separate issue from what the right rule is as to how things transpire in the district courts.
Could I perhaps try to solve it in a different way? What I would suggest, we spent some time trying to catalog the cases in which this court has approved universal injunctive relief and the cases in which it's rejected it, with the aim of giving the court maybe a suggestion on how it might affirmatively articulate some limiting principles such that you would not be getting the injunctions that the court thinks are inappropriate, but the ones that the court has approved would still be able to proceed. Again, that's not the categorical rule that the government is suggesting. I think roughly what the court has been doing is saying that universal injunctions are appropriate only in facial challenges involving fundamental constitutional rights, where there are real concerns about whether just the legal and practical availability of relief to similarly situated parties who are also going to experience irreparable harm. I think that maybe explains AARP. Most recently, IRAP would fall into that category. Crucifix, the New York eviction case, would fall in that category. On the other side of the ledger, the court seems to disapprove quite a bit of nationwide injunctions involving discretionary benefits. So that's some of the recent ones that you have undone or stayed. So I think what the court could do is kind of identifying limiting principles that would provide guidance to the lower courts on when it's appropriate to issue these injunctions. The natural home for that is the public interest prong of the Winter test, right? If you're going to issue an injunction that's going to have an impact on other people's, you need to be doing a really muscular public interest assessment before doing that. So that's what I would urge the court.
Ms. Corcoran, are you pushing back on the class certification idea because you're worried that there are cases where there will be no certification, but in which broad relief is in fact appropriate, so
Yes.
that the two categories don't line up? And if that's why you're pushing back, why are you worried about that? What are the cases you're worried won't line up properly in that way?
The government has suggested it's going to argue that here. Again, I think the commonality, so thinking about questions like common injury make a lot of sense when you're talking about class-wide damages. less so when you're talking about a facial challenge to a constitutional violation. So I think it's a bit of a mismatch. And again, it's not what Rule 23 was ever intended to do. And it doesn't solve any of the court's policy problems. So I think it's a lose-lose-lose proposal that the government is offering. I'm a little concerned that I have focused a lot on my amici hat and haven't actually explained to the court why the injunction is necessary for complete relief here. But I don't want to pivot too quickly, but I want to make sure I address our primary argument as well.
Tell us why it's necessary for complete relief.
Thank you. For two reasons. The first is that a plaintiff-specific injunction would not be administratively workable. I'll explain that in a second, but I want to note the second one is that even if it were workable, it would require the association members to identify and disclose to the government an association that puts them at great risk of adverse consequences, detention or deportation, even if they're here lawfully. And so it's not complete relief to require the plaintiffs to make dangerous disclosures in order to claim the constitutional right. And then maybe I'll pivot back to the workability unless there are questions about that. Sorry.
Very briefly, and then we'll move on to the next stage of our questioning.
So the government's workability argument with respect to the individual plaintiffs, the private plaintiffs, is wholly tethered to its argument that the injunction should be limited to the 16 named plaintiffs. It has offered no argument for how it would administer, how state and local agencies could administer an injunction that was narrowed to the ASAP and CASA members. So I think that's probably the end of the road. Mr. Feigenbaum made the point that they can always go back to the district court and ask for the injunction to be dissolved if they present some sort of workable proposal. They haven't, and I don't think they can. I don't want to talk for too long, but if anyone is interested, I'm happy to answer questions about why I think it's
I'm
unworkable.
sure someone will be.
Yeah.
Thank you, though, Counsel. Justice Thomas? Justice Alito?
Should we decide or make up our minds on the underlying birthright citizenship question without briefing and argument and deliberation?
I think that we would be very eager to do supplemental briefing on that. General Sauer noted that none of the parties had asked for cert before judgment. We couldn't because we keep winning. I will ask right now for cert before judgment.
What's the answer to my question?
Yes, I think you can grant cert before judgment.
That wasn't my question.
Yeah, but I will say,
all right, that's all right. You don't want to answer it. That's
no, I will. I have if I could give an answer, which is that I think it's very difficult, if or not impossible, for the court to do a meaningful in-ken analysis without taking into account the fact that the government is asking the court to allow it to ignore this court's precedent, to ignore a duly enacted statute, and to upend 100 years of executive branch practice. So I think, although the government has attempted to separate them, that really the merits are embedded in the in-ken factors.
Justice Sotomayor?
I find it hard to understand how a district court, in looking at a preliminary injunction under the winter factors, where we said that the likelihood of success on the merits is the keystone, how we could separate that out and say the keystone of whether you're entitled to universal injunction is the only merits question because the other factors are not eliminated by winter. You have to balance the equities, and you can't balance the equities without the merits, correct?
I think that's right. I think also, irreparable harm is going to be very difficult for the government to prove if it's not contesting or at least not defending the constitutionality of the order, because the government has no interest in enforcing an unconstitutional order. I'd also note there's a quote from Professor Bray in Justice Gorsuch's Texas Concurrence, and it's, "In equity, it all connects. The broader and deeper the relief the plaintiff seeks, the stronger the plaintiff's story has to be." So I think there really is kind of an equitable consideration here of the merits as well that just can't be extracted from the...
Now, the state has explained why it can't pursue class actions. So it admits it's limited to whether it's entitled to complete relief. But how about your organization? You sort of answered it, but I wanted to pin you down on that.
No,
Do you believe that associational organizations can seek class action?
I believe our individual plaintiffs certainly can.
Yes, there's no question.
Yeah, I am nervous about the government's suggestion that it's going to oppose our class certification motion if we were to file one. I mean, class certification can be very discovery intensive. It could be the sort of thing that really delays our plaintiffs from getting the relief that they seek.
Thank you.
Justice Kagan?
I guess what I worry about, Ms. Corcoran, is this case is very different from a lot of our nationwide injunction cases in which many of us have expressed frustration at the way district courts are doing their business. And, the typical way in which that frustration emerges is that legal questions are hard and they're complicated, and different courts would decide them differently. And instead, because of the forum selection process, a party goes to one place. In the first Trump administration, it was all done in San Francisco. And then in the next administration, it was all done in Texas.
Right.
And there is a big problem that is created by that mechanism. And that leads to the questions to you and to General Feigenbaum, which is your third buckets, which are, if it's super important, or if it's quintessentially national, or whatever the way, is not going to solve our problem for that set of cases, which is not this case. This case, what's problematic about it is that the courts keep deciding the same way, and nobody really thinks that the lower courts are going to do anything different. And for that reason, it does present the catch-me-if-you-can problem that Justice Jackson said, and the problem of how are we ever going to get a case here. But our general case is not like that, and I just want you to sort of comment on that.
Yeah, I'd say first that the government's proposal of channeling through Rule 23 does nothing to solve anything you just described. I think the limiting principles that I was proposing, which again was just me trying to reflect back to the court, kind of the through lines that it's been identifying, are sufficiently concrete that if this court were to articulate them, it would cut back on the number of universal injunctions. Is it a facial challenge? Does it involve a fundamental constitutional right? Right. Those are concrete questions. And then I would point to Justice Kavanaugh's Poe concurrence. I think vertical stare decisis is going to be important here. When courts enter these sorts of injunctions, they're immediately appealable to the courts of appeals. So if there are any district courts that are kind of getting over their skis on these, it's correctable by the courts of appeals.
Justice Gorsuch, Justice Kavanaugh?
Some of your concerns about this court being involved, because I'm not sure I really understand that. When a president or an administration enacts some major new rule, the question ultimately, and it's legally challenged, ultimately it'll be a year or two from now, it'll get here and we'll make a final judgment. But the interim status of that rule, as this case illustrates, and many others, vaccine mandate, eviction moratorium, go down the list, they're really important whether they're in effect for that year or two. And I guess I don't know why you should be concerned or we should be concerned about this court playing a role in this.
Oh, I don't have concerns about that. I was responding to General Sauer's point that this has become pathological in the number of universal injunctions that are making its way onto the court's emergency docket.
Just because there are more significant executive actions over the last three decades.
I certainly agree with that, and
that are at the Loper Bright and our West Virginia versus EPA are arguably some part of that story as well.
I agree completely, and to answer the question you asked General Sauer earlier about why have we seen this proliferation of these universal injunctions, I think it's directly, I would say first that the government, I think, pretty dramatically overstates them. It's double counting TROs and PIs in the same case. But if you look at the number of executive actions in the first 6 weeks of this administration, it's more than any other president issued in a year dating back to 1951 during the Korean War.
But I don't want to sing, it's, it's going back. It's bipartisan phenomenon, completely bipartisan and completely, in my view, well-intentioned because presidents want to get things done.
Right,
and I get that.
I agree with that. I think it's directly correlated to the number of unilateral executive actions we've seen over the last few years.
Justice Barrett?
Ms. Corcoran, I just have one question. You said that you're in bucket one, so you felt like you were playing kind of the amici role. I understand why you might think you're in bucket one for the associational point. Do you think you're in bucket one for individual plaintiffs?
So I don't know that I would extract them because the
Well,
Universal
named
Injunction-
plaintiff, like let's imagine you had individual plaintiffs that are named members of the association. So I guess what I'm saying is let's take the association outside of it and let's just say that we're talking about individual plaintiffs.
So
Would you
there,
put that in bucket one?
So there I would go to the second injury I had identified earlier, which is if you're asking, our individual plaintiffs have pseudonyms right now. That would be contemplating a scenario where they would have to identify themselves to the federal government and say, I am an ace, or I'm the plaintiff in this case, at which point they are immediately vulnerable to deportation, even again if they're here lawfully. We've seen the government removing visa holders and asylum seekers.
Justice Jackson?
So I think I understand your arguments. There's just one little piece of it that is confusing to me, and I hope you can clarify. So if we view the relief in this case and others like it to be a judgment ordering the defendant not to do something that the court has found to be likely, because we're in the interim stage, unlawful, are non-parties in that situation actually getting relief, or are they just incidental beneficiaries of an order requiring the government not to do this harmful thing? I thought it was the latter. Yeah. And that just, the government is told by the court, don't do X. And of course, anybody who would have been harmed by the government doing X is benefited by that. But they're not really, I thought, getting relief. But here's where I get confused, because I thought they're not getting relief because they can't come into court independently and seek a contempt ruling if the government continues to do the thing. They weren't parties. They don't have the judgment. That's what differentiates them from, say, the class action people or the plaintiff people. The reason why we have the rules for class action, et cetera, is because at the end of the day, the members of the class are getting a judgment that they can then use to enforce this obligation as against the government, whereas the people in the universal injunction world are just benefiting if the government actually follows the order.
Yeah, I think that what you're articulating is consistent with a long history of precedent and practice. I mean, it's the classic REM case, right? Making a declaration about property. I think Professor Fander's amicus brief is really helpful on that. He talks about the patent laws. And I think you can see that same instinct in the court's cases that Justice Sotomayor was talking about earlier, right? The railroad rates, Barnett, Pierce v. Society of Sisters.
And I guess my point is that's why we don't need Rule 23, because we're actually doing conceptually a different thing. We're not trying to give all these people, everyone in the world, some sort of enforceable right as against the government. We are simply just doing what courts do, I thought, which is telling the defendant over whom they have personal jurisdiction that they have to stop doing something unlawful. And of course that benefits people. But the thing that confuses me about your argument is that you alluded at the beginning to Rule 71 and suggested that the non-parties could somehow enforce this universal injunction. I didn't understand.
I think Rule 71 contemplates that. It would be very onerous. I mean, I think when General Sauer, he was kind of contemplating the idea that, tens of thousands of people were going to have to come to court individually.
Right, but I think if you're right about that, it undermines the point that I'm making, because it puts people in the same place as the class action folks and the parties in a way that I think raises legitimate concerns that some of my colleagues have put forward with respect to universal injunctions. So the thing that distinguishes them is that universal injunctions are not benefiting or giving relief to non-parties in any meaningful sense, is my theory.
I think both have always been true, and maybe they're in tension with each other, but Rule 71's originated in Equity Rule X, which was enacted was put in place in 1842, which had this same idea of, quite apart from representative suits, non-parties enforcing orders that provided them with relief. Although maybe this, as I'm talking, I think maybe I'm talking about under Rule 71, orders that provide relief.
But let me just
You're talking about
this.
injunctions.
Yes,
right.
what I'm asking you
Those are
is,
different things.
in this very case, if we have a series of plaintiffs, of actually named people, and they get an injunction, as the government says, against, if they get a universal injunction, or what they call a universal injunction, the government cannot enforce this executive order. can someone who is not a non-plaintiff come into court to enforce that if the government violates it?
So I'm hesitant to say no, both because Rule 71 exists and those aren't my clients are my plaintiffs, and we needed this universal injunction.
Yes, I understand. I'm just trying to figure this out.
But I think both, I think both what you said is true. If we look at cases like Barnett and Pierce, and we go all the way back, I think Justice Story's dissent that he signed on to in Cherokee Nation v. Georgia is terrific on this point. He was the preeminent scholar on equitable remedies, and he certainly thought, in the way that you're articulating, we are going to make a declaration about whether Georgia can enforce its laws on Cherokee Nation property, and that is just a declaration of the law that will have an impact on everyone. But I'm hesitant to say that Rule 71 doesn't have any application.
Thank you.
Thank you, counsel. Rebuttal, General Sauer?
Thank you, Mr. Chief Justice. The original meaning of the Citizenship Clause extended citizenship to the children of former slaves, not to people who are unlawfully or temporarily present in the United States. The merits arguments we are presenting to the lower courts are compelling. We cite, for example, a host of 19th century authorities that point out that domicile was the touchstone of non-citizens being treated as having their offspring treated as citizens in that context. That is consistent with Wong Kim Ark, as well as with the slaughterhouse cases in Elk against Wilkins, and the suggestion that our position on the merits is weak is profoundly mistaken. And that kind of snap judgment on the merits that was presented in the lower courts is exactly the problem with the issue of racing to issue these nationwide injunctions. The Chief Justice correctly pointed out that this court, if it wishes to address the merits expeditiously, has many tools to do so. Cert before judgment is one possible tool. There are also others. But this court should also address the scope of remedy, the remedial question that's presented in the application. That is an extremely urgent question. And one of the reasons it's an extremely urgent question is the limiting principles that my friends on the other side have been offering have all proven to be completely ineffective to slowing the essentially flood or cascade of universal injunctions that we see in these cases. The states here have a unique issue that hasn't come up yet, but for the reasons we state in our application, they lack third-party standing very clearly under cases like Murphy and Hayland and Katzenbach and Kowalski. So no injunctive relief should run to the states in this particular case anyway. And most fundamentally, the vision of the district courts that's reflected in the issuance of these nationwide injunctions is a vision of them as a roving commission to correct every legal wrong that they can consider and to exercise general legal oversight over the executive branch, which is what this court rejected in TransUnion. And for those reasons, we ask the court to grant the applications.
Thank you, counsel. The case is submitted.
Until Thursday, the 22nd of May at 10 o'clock.
King of the trap.